City of Dearborn versus West Dearborn Partners. Each side has 15 minutes. You may proceed.
Thank you, Your Honors. May it please the Court, Robert G. Kamenec with my partner Scott Lights. We represent West Dearborn Partners, who I'll refer to as West Dearborn throughout this argument. Your Honor, I'd like to reserve 3 minutes for rebuttal if I need it. Unlike the previous case that I just argued, we have 3 issues here. And I plan on going through them fairly quickly with the Court's indulgence. The first and primary issue involves the effect of a bankruptcy court order. And both of the lower courts found that a mortgage interest that was held by West Dearborn was extinguished by this particular bankruptcy court order because the accompanying assignment of the mortgage and the note was not recorded. The bankruptcy order indicating that it was only recorded interests that survived. The rulings are incorrect for the simple reason that West Dearborn owned the note. They purchased the note before the time of the bankruptcy court order. As we've briefed, Michigan abides by the mortgage follows the note doctrine. By operation of law, that mortgage was owned by West Dearborn. Its ownership interest in the mortgage survived the bankruptcy court order. And why that is because the mortgage had been previously recorded with the court. So it constituted under the bankruptcy court order an interest that had been recorded with the court. All 4 judges who have looked at this have missed that point. And I think it resolves the first issue, if I may. And again, I know I'm batting clean up for the day, so I'm going to try to make this as quick as possible and then answer any questions. The second issue, I'm going to take the third issue first, the estoppel issue. It's in the briefing. The Court of Appeals totally got it wrong. There were statements made when the City of Dearborn went into the bankruptcy court, it wanted to purchase the subject property. It told the bankruptcy judge that all of West Dearborn's interests were protected. And why did it do that? Because West Dearborn had a mortgage interest, and obviously if there was a mortgage interest out there, the property was worth less. So all these assurances were given to the bankruptcy judge, and they're in the transcript and they're very clear. The bankruptcy judge agrees with them and indicates that on the record of that hearing that all the interests are protected. And because there's a mortgage that applies and it's protected, applied to the property, guess what? The City of Dearborn gets to buy it for $1. So they get it dirt cheap. And then what happens? Then they turn around and say, no, that's not what we said. That's not what we meant. You, West Dearborn, you didn't have any mortgage interest. We get the property free and clear for $1. And it's in the debate, but there's 2 doctrines at play here. One is estoppel, because obviously, and it's judicial estoppel as well as equitable. You can't go into one court and take one position and be successful. And that's required under judicial estoppel. And they were successful in the bankruptcy court because they got the property for $1, and then turn around and take a diametrically opposed position to the detriment of the other party. And that's exactly what happened here. In West Dearborn, strike that, in the City of Dearborn's briefing, they actually make an incredible argument about equitable rescission. I don't even have to go to the merits of it because all the justices of this court know that you can't go to equity if you have unclean hands. And boy, this is a case, this is Black's Law Dictionary of unclean hands. All through this case, the City of Dearborn took inconsistent positions. They knew better, and they didn't do it. I gave you one example already in the bankruptcy court, but I think even a better one relates back to the last issue that the court asked us to brief, and that was the effect of the BOA mortgage after the fact. The claimed discharge of the mortgage on the subject property was not at issue in 2015. It was a different parcel of property. So even if one were to say that BOA had rights in the property, which it didn't, because it had already sold the note and the mortgage, it didn't relate to this particular parcel of property. And I don't think there's any debate about that. Yet, what happened is the city of Dearborn understands full well that in that litigation, there was a mistake made by the Bank of America representative. And on file with this court and on file with the lower courts, as you know, is an affidavit of a Scrivener's error, indicating that when Judge Brian Sullivan signed the order of discharge with respect to the BOA mortgage in 2015, that it was erroneous. And that was on file with the court, and that was filed with the Register of Deeds. I would have thought that when at least the deposition of the person who signed the affidavit of Scrivener's errors was taken in this case, that maybe the lawsuit would have been dropped, because maybe the city of Dearborn would have understood at that point that it was barking up the tree the wrong way. But it didn't do it. Unfortunately, it stuck to its guns, and it's completely erroneous. So the BOA mortgage does not affect West Dearborn's mortgage interest, as I've just explained. Notions of equity, standing independent of the first issue, say that the city of Dearborn can't take the position it took in the Wayne County Circuit Court. This is completely and diametrically opposed to the position it admittedly took in the bankruptcy court about the viability and the survivability of West Dearborn's mortgage interest. Remember that it was the city of Dearborn that proffered and drafted the order in question. In the bankruptcy court, I must tell you, when that statement was made, we had our attorney there, a gentleman by the name of David Lerner. We had filed objections in the bankruptcy court saying you have to protect our interests. They knew, West Dearborn knew all about our interests because the assignment was filed with the bankruptcy court. And it was only based on West Dearborn's, the city of Dearborn's statements that our interests were protected, that we didn't pursue our objections. So we acted to the detriment of our position based on what they did. And finally, I go back to the first issue, not to be redundant. The mortgage interest survives. And unless, I know we gave you chapter and verse in the briefs, but I think it's all 50 states recognize the rule that the mortgage follows the note. And I think there's only 2 that have some sort of derivation. So the court should have the comfort that if it applies that rule, not only is there Michigan law that says it, but at a minimum, there's another 48 states that abide by that. So the lower courts got it wrong. I'd asked this court to enter an order reversing both the decisions that are made here, in particular, the Wayne County Circuit Court's decision, and remand for entry of summary disposition in favor of West Dearborn.
Thank you, Mr. Kamenec. Justice Bernstein?
Good morning. I just want to say it's nice to have you back. I'm glad we got to hear from you twice today.
Thank you, Your Honor. That's most gracious. Likewise.
My pleasure. Thank you. No questions.
Justice Clement?
No questions. Thank you.
Justice Cavanagh?
No questions.
Justice Markman?
Yes, Mr. Kamenec, I think I understand anyway your argument that Coventry is relevant here in terms of the assignee standing in the shoes of the assignor for all beneficial purposes. Where I'm a little bit less clear, however, is I haven't seen any direct argument on your part concerning the extent to which the discharge statute operates to extinguish any interest that West Dearborn may have had after it was abandoned by the bankruptcy court in 2011. Do you have any authority that would allow West Dearborn to retain its unrecorded interest in Parcel C despite Bank of America's discharge under 565.42?
If it's not in the brief, Your Honor, I don't have it.
Isn't that kind of an essential part of what you have to demonstrate here?
Well, I would suggest not for a couple reasons. One, upon careful review of the Wayne County Circuit Court's order, when you look at the actual order that was entered by the court, it did not discharge the mortgages to this property. And I would, if I may, I would encourage the court to look at the order at Appendix 224A and 225A. So the 4 corners of the actual order entered by the Wayne County Circuit Court did not discharge the mortgage as to this parcel of property. I don't believe the court has to go any farther than that.
Are you saying it didn't purport to discharge the mortgage, or it didn't, in fact, discharge the mortgage in light of some alternative authority?
I'm sorry, Your Honor, I'm not being clear. It did not discharge the mortgage as to this property. I'm looking at the order before me. What Judge Sullivan signed was an order that said that there's a discharge with respect to a property description in it. And the property description was not parcel C, it was parcel A3. And then I just repeat my argument that later on, over nobody's objection, the affidavit of scrivener's error was submitted to the court and filed with the Register of Deeds.
Okay, take a further look at...
Oh, sorry. Go ahead, Justice Markman.
No, I just said I'll have to take a further look at that. Thank you, Counsel.
Thank you, Your Honor.
Justice Zahra?
Thank you. I tend to see some merit in your first argument that when Bank of America assigned its interest in parcel C to West Dearborn was left with a lawful interest in the subject property. The mortgage follows the note, and Michigan law doesn't require it to be assigned. So I think you continue to have a possessory interest, ownership interest in the recorded mortgage even after the bankruptcy was entered, even though the assignment was unrecorded. But I'm stuck with the notion that your claim is really against Bank of America for discharging a mortgage they didn't have. Why do you still have a claim against the city?
Well, we are a defendant in this case. The city filed an action against us, if I understand things correctly. We simply, because our view is that Bank of America has no further interest in this under the existing court orders. There's been a decision that that the city owns the property because of the bankruptcy. They bought it for $1. They've got the property. We contend that our mortgage interest still attaches to it. So when they filed the action to quiet title, that's where our interests are, and that's since literally the city of Dearborn owns the property. We just want our mortgage to attach to it. I don't know if I'm answering your question, Your Honor.
Well, I guess it seems to me that the wrongful party here is Bank of America, and your remedy should be with them, not the city.
Perhaps, but if our mortgage is still alive, then our recourse is to make sure that that mortgage applies and attaches to the land that's owned by the city of Dearborn.
But the mortgage was discharged by Bank of America, was it not?
It was not discharged. Because the mortgage, with respect to the Bank of America, for one, the discharge did not go to this parcel of property. There were two parcels of property. Maybe I'm not explaining it well, and I apologize. But there were two parcels of property. The property in question that was subject to the discharge had to do with condominiums. And there's actually a printout of the property that's in the record at the appendix 23A. And what happened is that the lawsuit with respect to the discharge dealt with that parcel of property only. It did not deal with the parcel of property that is at issue here. So it's one thing to have the mortgage discharged as to a separate property that we're not contesting here. It's another thing to have the mortgage discharged with respect to property that was not involved in that lawsuit.
Mr. Kamenec, can I just interrupt for one moment, please?
Please.
I thought your argument was that the mortgage was discharged with regard to Bank of America, but nonetheless that Dearborn retained some interest of it was intact after that discharge. And my earlier question was, what was your legal authority for that? But do I understand even the premise of your argument? Again, I thought you had argued that West Dearborn retained an interest even after Bank of America was discharged.
Well, if I may, Your Honor, let me distinguish between a mortgage interest and ownership of the land. The city of Dearborn owns the property. The debate in this case is whether or not it's encumbered by a mortgage that's owned by West Dearborn, and perhaps I'm missing something here. So the issue is the viability of the encumbrance, which happens to be a mortgage. Is it held by Bank of America? Was it discharged by Bank of America? If discharged, does it mean that it reverts back? Wrong legal term, but does that mean that the West Dearborn owns it? There's no debate about any that I know of. No, it's not our position that the city of Dearborn has any mortgage interest on its own property. So,
did you have additional questions? I didn't. Justice Zahra?
No, thank you.
No. Okay. Justice Viviano?
No questions.
Thank you, Mr. Kamenec.
Thank you, Your Honor.
Thank you. Good afternoon, Chief Justice, fellow justices. May it please the court. My name is Richard Patton, and I'm appearing on behalf of the city of Dearborn, or just Dearborn, as I'll refer to it. The issue before the court today is whether West Dearborn Partners, or West Dearborn, has an interest in the real property located in the city of Dearborn known as Parcel C. Simply put, Dearborn's answer is no, it does not. Dearborn is asking this court to either deny West Dearborn's application for leave or simply affirm the Court of Appeals and the trial court, who both also answered this question in the negative. I am going to take the issues a bit out of order from our briefing based on how the argument's gone thus far. And I just want to say that it is undisputed that Bank of America was the mortgage holder of record until Bank of America discharged its mortgage in December of 2015. That means that the whole world, based on the recording, believed that Bank of America held the mortgage until it was discharged. More significantly, Bank of America believed that it held the mortgage until it was discharged. Bank of America's belief was not a fleeting mistake or a one-time oversight. In 2014, Bank of America was sued in a Wayne County Circuit Court lawsuit separate from this case, but related to the mortgage at issue in this case. And I just want to point out that in that lawsuit, Bank of America said that it held the construction mortgage as to parcels A3 and parcel C, which is the parcel at issue in this case. And that's at our appendix 58B and 60B, 260B, I apologize. Bank of America litigated an entire circuit court lawsuit from beginning to end, reinforcing to that court and the world that it was the holder of the mortgage. And when that lawsuit ended, it ended with an order to discharge the mortgage, and Bank of America complied and discharged its entire mortgage. To this day, neither Bank of America nor West Dearborn has sought to unravel that discharge with respect to parcel A3. I submit that this is strong support for the fact that Bank of America had the power and authority to record the discharge of mortgage. If it could discharge as to one, it could discharge as to all. Furthermore, imagine the legal chaos that would ensue if that discharge was invalidated by this court. It would have an extremely prejudicial effect on the litigation that is resolved in that other case, on the third parties from that other case, and all of the third parties that have been involved in that property since that time, and on the city of Dearborn. If West Dearborn had promptly recorded, as it was contractually required to do under its alleged agreement, needless litigation would have been avoided, and there would not be a giant cloud overshadowing title now for 9 years, half of which represents the time that West Dearborn refused to record. If you hold that an unrecorded assignment trumps a discharge of mortgage filed by the mortgagee of record, then you will sanction nearly a decade-long cloud on title and the legal chaos that has ensued from the refusal to record. And no one in Michigan could ever rely on such a discharge again. The real estate mortgage industry would grind to a halt. And not only would this court be creating a hole in the law where no one could rely on such a discharge, but it would be bailing out an assignee that refused to record its alleged interest for over 4.5 years. I do agree with one thing that Mr. Kamenec said, and that this is a clear case of unclean hands, but it is a clear case of unclean hands by West Dearborn. Furthermore, I would say that MCL 565.42 provides statutory authority for the mortgagee or assignee to record a discharge of mortgage. According to West Dearborn's way of thinking, the assignee and mortgagee would always be the same, but if that were true, then there would be no need to identify both a mortgagee and assignee in the list of those authorized to record a discharge. Additionally, MCL 600.3204 even authorizes the mortgagee of record to foreclose by advertisement, even if there are subsequent unrecorded assignments. And this court has held that the record holder of the mortgage may foreclose and that the validity of the foreclosure is not affected by an unrecorded assignment of interest. That's Arnold v. DMR Financial, 448 Mich 671 at 678. Furthermore, MCL 565.33 permits a mortgagor to make payments to a mortgagee, even if an assignment of mortgage has occurred and was recorded. So based on the foregoing authority, Dearborn submits that if a mortgagee of record can foreclose and accept payments in satisfaction of a mortgage, even with an unrecorded assignment, then by even greater force of logic, a mortgagee of record may also discharge the mortgage. Now, regarding the bankruptcy order, West Dearborn's attempt to bootstrap itself to the of-record status of Bank of America, we believe is unavailing for multiple reasons that we have fully set forth in our brief, but I would like to highlight a few short points, if I may.
Mr. Penn, let me interrupt you. If my colleagues have questions, I don't want your time all used up and they don't have a chance to ask them. And then if
yes, Your Honor, thank you.
We'll get back to that. Starting with Justice Bernstein.
Actually, if it's okay, counsel, I would really be interested in hearing the specific arguments you were going to make.
Well, there you go. He overruled me.
Well, I got
Sure.
Oh, you have a specific question, Justice Clement? I'm going to go to that first. Justice Bernstein, we'll get back to you.
No, that'd be great. Thank you.
I think it might be helpful if you could explain just how common it is for a bankruptcy court to not preserve unrecorded interests.
Your Honor, unfortunately, I can't speak to how common that is or is not. I mean, to my mind and to my experience, I think that part of this case may be a unique fact. However, I don't think that the law related to the discharge is unique at all, as I said before.
Okay, thank you.
Thank you.
Justice Cavanagh?
I have no questions.
Justice Markman?
Yes, counsel. I don't know what the extent is of the availability of potential equitable relief here of the sort that West Dearborn is arguing for, and it's not my purpose right now to urge that or urge against that. But in this case, my understanding is that, number one, you had knowledge of the mortgage on the property. Number two, your attorney admitted at the bankruptcy hearing that West Dearborn, in fact, claimed an interest as an assignee of the mortgage. And third, you were aware, I think, of the fact that Bank of America's attorney had executed an affidavit that corrected its error concerning the discharge with respect to Parcel C. I mean, do you think that those things together give rise to any reasonable, equitable argument in support of West Dearborn's position?
No, Your Honor, I do not. And let me take those.
I thought you wouldn't, actually.
And let me take those those issues, I guess, in reverse order. As to the affidavit, and I'm glad you asked this, I meant to bring this up in response as well. The affidavit is of no effect, in our opinion, as we argued in the brief, Your Honor, because that affidavit attempts to alter the substantive rights of a party that did not execute it, and that is MCL 565.451D2B. And so I think that's the answer with respect to the affidavit, Your Honor. With respect to the fact that they're saying they claimed an interest, well, did they claim an interest in the bankruptcy? I think that was questioned. In fact, I know that it was questioned by my client in the bankruptcy when we said they've provided no explanation for why they haven't recorded this alleged assignment in 5 months since this transaction apparently took place. And if the court examines the transaction that they're claiming gives them the right to the note, that transaction, and we've cited this in our brief, says that they must promptly record that assignment in order to effect the transaction contemplated in the agreement. So they didn't do that. As to the knowledge of a mortgage, then that I think begs the question, Your Honor, well, who's the mortgage holder? And the mortgage holder of record, which Mr. Kamenec said only recorded interest survives the bankruptcy order, the only recorded interest at the time, Your Honor, was that of Bank of America. The interest of West Dearborn was not of record. And so, no, I don't think that all of those things together or even separately would cause this court to render some equitable reversal based on those issues. And if I may, Your Honor, the specific law that they're trying to hang their hat on with respect to equitable estoppel and judicial estoppel does not apply for the reasons that the Court of Appeals explained in its opinion. And that is that there were not wholly inconsistent statements. We always took the position in bankruptcy and have taken the position in this case that it was an alleged assignment. There was a question about it. They didn't record it. So our statements are not inconsistent. And moreover, the bankruptcy court didn't accept anything as true. The court didn't decide the validity of the assignment. So you don't get there through the requirements and the elements of judicial estoppel. And as to equitable estoppel, I would say that they're also missing a key element of reliance. Now, I understand Mr. Kamenec argued reliance, but there's no citation in the record evidence that any attorney at that bankruptcy hearing or thereafter relied on what was said or not said at that hearing.
Thank you, counsel.
Thank you.
I just muted myself. Sorry about that. Justice Zahra, I'm sorry, I didn't mean to skip you.
No questions, thank you.
Justice Viviano?
No questions. Thank you, counsel.
Justice Bernstein, were there additional things you wanted to hear?
No, I think I'm good, but counsel, there were like two other arguments that you were going to make, and if you could briefly do those.
Yes, thank you very much. Where I left off was with respect to the bankruptcy order itself, and I just would like to highlight a few short points. First, West Dearborn conceded that its alleged interest was not of record when it filed its objection in the bankruptcy case, asking the court that any order preserve not only interests of record, but also West Dearborn's alleged unrecorded assignment. That is, it admitted in the bankruptcy court level that its unrecorded alleged interest stood on different ground. Second, West Dearborn invoked the jurisdiction of the bankruptcy court, staying this present case, and asked Judge McIver in the bankruptcy court to interpret her order of abandonment in favor of preserving West Dearborn's unrecorded assignment. And that motion was simply denied, and they chose not to appeal that denial. Finally, the Court of Appeals got it right when it said that even if you accept that West Dearborn stood in Bank of America's shoes for purposes of the mortgage, then West Dearborn stood in those same shoes when Bank of America discharged that mortgage in 2015. Against the backdrop of legal chaos, created by West Dearborn's deliberate decision not to record, resulting in multiple lawsuits and a 9-year cloud on title, it audaciously asks this court to place it on the equitable high ground. Again, we've touched on these issues of equity, and I won't just repeat what we've said in the brief, but I do want to emphasize that getting this Parcel C was not a windfall. As an initial matter, the taxpayers of Dearborn never got the benefit of their bargain by having Parcel C developed, despite having built 2 large parking decks that now flank a vacant hole in the middle of the city. The property is not an asset, it is a liability. And if gaining the property was such a windfall to West Dearborn, why did they not ever try, at least, to foreclose? And the answer, we believe, is that West Dearborn knew Parcel C was a detriment, and it would become subject to very costly development obligations in the covenant deed and development agreement to develop the property. In conclusion, I would say, Your Honor, this court should decline the request to bail West Dearborn out of its own deliberate decision not to record. And to quote the trial court and Court of Appeals, it is not the role of the court to protect sophisticated parties and their counsel from their own mistakes or deliberate actions taken to their detriment. Thank you.
Thank you, counsel.
Thank you very much, Mr. Patton. Mr. Kamenec, I think we blew through your rebuttal time, so the case will be submitted. I want to thank you both for your arguments. That concludes.
Actually, Chief, if it's okay, I would just like him to have a chance to, because I just want to see if he could just give a brief response to the windfall component, if that's okay.
Yeah, absolutely. Yeah, Mr. Kamenec, you're back on.
Thank you, Your Honor, and thank you for asking the question. It should not be lost on the court that my client bought the note and bought the mortgage from Bank of America before the bankruptcy court order was entered. Then, as I previously explained, and it had an encumbrance on the subject property. When the City of Dearborn went into the bankruptcy court after we had filed objections to retain our mortgage interest, the City of Dearborn, through its counsel, made representations that allowed and convinced our client to withdraw those objections, because the City of Dearborn made clear that the very order that it proposed protected our interest. In so doing, and in so acknowledging at that point that the property was encumbered, then obviously you could buy it from the trustee at a lower price. Because of any property, if you buy it, if it's encumbered, is worth less. So it did have the opportunity at that point in time, based on its representations, to obtain this property for $1. Obviously with the notion that there's a mortgage out there that subsumes the value of the property in the first place. The windfall occurs when you change gears and you say, you know what we said there doesn't count. We believe that there's no mortgage. And accordingly, when you say there's no mortgage on property, that it's not encumbered, the property is obviously worth a lot more. So in many ways, that's the windfall. And right now, under the status quo, Justice Bernstein, the City of Dearborn owns the property and it's not subject to the mortgage. So they paid $1 for the property under one set of facts that it represented. And then based on another set of facts that it represented and convinced the Wayne County Circuit Court to accept in the Court of Appeals, it gets to keep the property at a greater price, at a greater value. And that, in a nutshell, rather long nutshell, but that's the windfall.
Thank you, counsel.
Thank you, Mr. Kamenec. The case will now be submitted, and that concludes today's case call. Thank you both.
Thank you, Your Honors.
Thank you.